There is no concept of collecting any maintenance per se under the Act.
What exactly does the deed of declaration do? What is it for?
You cannot register an apartment association under Karnataka Society Registration Act.
So the deed of declaration is a choice, but only under the 𝗀𝗂𝗋.
Correct.
Okay.
So you make a choice whether you want to be governed under this Act or not.
Okay.
That's how the Act is designed. You have to choose.
So
You can choose. You can not choose saying that I don't want to be governed under this Act. There are other acts that I want to be governed under.
You spoke of 3 different ones. So 2 of them can be utilized for the
Resident Welfare Association,
Correct.
which is Cooperative Society, Karnataka Apartment
ownership.
Ownership Act. I also understand, I just want to bring this to the notice of the audience. I also understand that there's a lot of debate going on today that there's a PIL that's filed before the Karnataka High Court as to the KOA is not the right act and, etc. So everything that I'm saying is as the way it stands today. Now, there could be changes in the future.
Correct.
Nobody knows.
Yes.
My only advice to the audience is that please don't read news articles and get perturbed. Wait for the legislation to come out or wait for the court judgment to come out.
So you're saying that until the judgment comes, we can still follow what is an
The
act
current
and
law.
current law and an act today. So we don't need to worry about what happens tomorrow.
Correct.
Even if something is passed as an act tomorrow, it should take care of whatever is happening today.
Absolutely.
So there should not be an upheaval of things.
Correct. Because as of today, there are Karnataka High Court judgments which says you can form association under Karnataka Apartment Ownership Act. So while the judiciary is also giving direction in that fashion, there is no need for you to get scared saying this is not the right act. It may not be. We don't know. But I think we should all wait it out, because even if the legislature is going to come in and design something new or a fresh altogether, it is going to take care of associations that have already been registered under various acts. Why are associations that are registered under cooperative societies are going to suffer? Because the act in the first place never allowed you to register an apartment association under the act. So therefore, people who are registered under Karnataka Society Registration Act have to figure out how to transition. But those that have been registered under other acts, I don't think there is a need to worry or get disturbed, because as of today, it's legal.
Got it. Now that we've got the umbrella,
I'm sorry, one more thing that I want to mention is you can also register resident welfare associations as a Section 8 company, a non-profit organization. You can also register under the Partnership Act. So these are also options, but they're not highly experimented because there are too many share issue, ratios issue. How do we do it? How do we structure it? And compliances thereafter. So it's not extremely conducive. It's like
running a small company. At the end of the day, it's an LLP or a private limited company you need to run. Okay. Understood. Now we've had the umbrella. We have an idea of the various acts that allow you to run your society the way you like. As you said, it's an opt-in. You do have management committee members who take the responsibility for running these. What are the legal ramifications, if I can call that, or what are the fiduciary responsibilities of these office bearers?
Right. So the office bearers are governed by the bylaws. So every association, no matter which act you're registered under, have these set of bylaws, which are your rules in terms of how to operate and run. These rules and regulations have to be in consonance with the act that you're registered under.
Okay.
So your responsibilities and your obligations and all of that is coming out of these bylaws.
Okay.
So it's how you structured it.
The reason for this question is, I'm sure you've heard of recently, there was an unfortunate incident in one of the societies where a young girl, due to reasons, passed away. Now, the president of that society was then taken to jail. A lot of the people now are unwilling to take these positions. So what would you have to say to those people? Because is that something that they need to be worried about, or can something be done so that they don't need to be scared that any misstep will land them in jail?
So the way I look at it is that why do you form an association? Because you want to take care of the property. You don't want the property value to depreciate. people who are living in that community want to benefit out of the facilities that that property has to offer, right? Now, anybody who's coming into the governing committee, this is your primary objective. That I want to maintain a property which is beneficial for everybody, including myself, and we keep it in such a way that there is always appreciation for the apartments here.
Correct.
That's the objective. Now, if this is not your objective, then you shouldn't be stepping into the governing committee.
Okay.
Now, in the example that you took, I'm not sure, but I don't know what's gone wrong there, but without commenting on the facts in that case, it is a primary responsibility of the office bearers who come in to maintain the property.
Correct.
So you can't escape that. You can't say, I will not maintain the property at the same time not face liability. That's not how it works.
Okay.
If you are going into a responsible role, it's like company, right? Where let's say if I get appointed as the CEO of the company, I have to run the company. If I'm failing at it, then I have to step down. So it's very similar. Now, of course, when you're part of the governing committee, you have these responsibilities. So anything that goes wrong with respect to the common areas, it is your responsibility. So you ought to take care. Now, if something that is not within your control takes place, then there is always a rule which says that, I am covered being an office bearer.
Okay.
Because I'm an office bearer, I am, it's like it's like indemnity. I'm indemnified because of my role as an office bearer to the extent that this issue that happened
Was beyond my control.
was beyond my control.
Got it. What are the financial responsibilities? What are the other responsibilities that they need to be aware of? What are the various things that, you have various roles. You have the
Right.
president, you have the secretary, you have the accounting
Treasurer.
person, the treasurer, etc. So what are their roles? Because I'm sure somebody who takes a position should understand what their responsibilities are and what is the consequence of somebody not performing their roles. You already talked about if they're there and they need to take care of advancement of the whole society. If that fails, then you are liable to be prosecuted.
Right.
So
in terms of finance, of course, there are treasurers. So the designations that we're carving out, like president, secretary, treasurer, these are all arising out of the bylaws. So if your bylaws provide for these designations, great, you can have it. If the bylaws don't provide for designation, you can still have the designation by passing regular board resolutions, by nominating people. That is doable. Even if your bylaws don't provide for certain things, you can do it with respect to
it
board
seems that the
resolutions.
bylaws seem to be an
Very
important part.
Very important.
So when the bylaws are being formulated, it's important that they talk to somebody who understands what they're doing and go through the bylaws.
Right.
So when are the bylaws formulated? Is it at the same time when the DOD is formulated? Do the residents who come and join later have an opportunity to reframe the bylaws?
Right. So yes, to answer your question, bylaws get formulated at the time when the DOD is registered, because bylaw is an important annexure to the DOD.
Okay.
So in most associations that are registered under Karnataka apartment, or any association which is registered by the developer, the bylaws is coming from the developer or the builder.
So this is not standard then?
From the builder's point of view, it's standard, because they will circulate a standard bylaw. It's not custom made to such a large extent. They'll give you a working bylaw.
Okay.
We've seen in our own, we have a lot of clients who are apartment associations. So when we deal with them, we've seen that a lot of conflicting rules in the bylaws itself.
Okay.
So 95% of the cases, when you start or when you're in the process of handover, you will observe that there's already an association that is registered under any one of these acts, and you're also getting the bylaws.
Okay.
So my advice to people who already get these bylaws is, please work around this to understand where are the issues. Once issues are identified, try to amend your bylaws. In my experience, what I've seen is that in order to amend bylaws, a lot of bylaws have this rule that you need 2/3 majority, not just majority, present and majority. So the question that is most asked for is, where do I get this 2/3? You have to get it. If you don't get it, then you'll have to approach courts. So there's a way to work around it, but this would be the right way, that see what the conflicting issues in the bylaws
When
is.
you say 2/3, it's 2/3 of owners.
Owners.
If the apartment is not yet sold completely,
Then the apartment belongs to someone, right? It probably belongs to the landowner.
say,
Or
okay, that's an interesting point. So there's something just occurred to me. Say a builder has got land from a landowner, and they have built 100 units.
right.
The 100 units currently are under whose name? They're under the name of the landowner and under the name of the builder.
Right.
Right? So they themselves form 50% of the each or whatever of the portions of ownership.
So I can explain the process.
Yeah.
Generally, what happens is if a landowner has 5 acres, he can construct the apartment complex himself. If he does not want to, and if he wants to do it as a joint development with a developer, he gets into a joint development agreement.
Correct.
Wherein commercially they will agree what is the ratio of land and building that sort of goes to the developer and the landowner retains. It could be a 70-30, it could be a 60-40, it could be a 50-50, any ratio that's commercially agreed between the two parties. And that joint development agreement gives rights to the developer.
Got it. And we
Indicating
spoke of
his
this
share.
last time also,
Yeah.
yes.
Now, after this, generally, the parties get into a supplemental agreement or a sharing agreement. The reason this agreement is entered into at a later point is because at the time of JDA, sometimes you don't have the numbers in place.
Correct.
But once the building starts getting constructed, once a sanction plan is in order or in place, then they get into a sharing agreement because they know how many apartments are being built.
Correct.
And let's take the scenario that you presented where you're saying 100 apartments, right? Let's say 50 to the landowner, 50 to the developer. The number of apartments and which block goes to whom is part of the sharing agreement.
Correct.
So, based on the sharing agreement, you will know how many apartments are sold, and whatever apartments is left, you will know whose share it is.
So you have to get then signatures from the landowner and from the builder and the other owners who've bought properties to get a 2/3 majority to change.
Absolutely, they are like any other. If the
Yes.
builder, let's say today, retains 15 apartments in an apartment complex, the builder is the owner of those 15 apartments,
Got it.
and they are part of your
Perfect.
RWA and governing and all of that.
Correct. Can the builder hold, if the builder is staying and owns property there, can they have positions of power in the RWA?
Absolutely.
Is that not a conflict of interest?
So it is not a conflict of interest because they have sold most of their apartments. And now, how do you call it conflict of interest? I don't see the conflict here. Because I've constructed.
You have
It has nothing to do with governing council.
Okay, now I have 100 units, I retain 10 units. So I get more votes than anybody else, and I am the president of the society. So don't I have then lot
So
more
it is
power?
a situation where, let's say, there is somebody who intends on buying 20 apartments in a complex of 100 apartments. It's a similar situation, right?
Okay.
If I, let's say, buy 20 apartments, that means, I'm dominating in terms of my votes. But if your bylaw says 1 vote per flat, then that's how it is.
Okay. Now that we've established under which act a society can be formed and the various responsibilities everybody has, one of the things that a society needs to do for running is to collect maintenance. Now, maintenance is collected based on different calculations and different formulas. There have been cases where people have either refused to pay maintenance or people just don't pay maintenance because of various reasons. What is the legal recourse for a society or the management committee if this happens?
Right. So yes, this is a common problem. That's something that I've also observed. The way I look at it is, if you're unable to recover the amount within 6 months to a year, then you don't have a choice but to go to the court of law.
When you say recover the amount, what do you mean?
So you give notices. A lot of bylaws, in my observation, have a penalty clause. So you send notice, you send your monthly invoices, then you also send your penalty notice, all of that. And despite that, if the owner is not paying, of course, the best way to see is how can I resolve this in my general body meeting, if that's permissible. If nothing is working, then you don't have an option but to file a case of recovery before the court of law to recover this amount.
what we have seen in certain situations are like this. You have a resident who's saying, I have complained about X, Y, and Z that the society needs to take care of so that it solves my problem. The society, the management committee has turned a blind eye to my request, and the reason for the society management committee there is to take care of me. They have not done it, so I refuse to pay.
Right. So this is like, this is like a threat saying if you don't do what I want you to do. In law, there is no definition of a handover takeover process as such.
What is the recourse that a resident has if tomorrow the occupancy certificate itself is forged?
Right. So first is to be aware of every single document that you are taking over, which will also help you understanding your own land.